Hello and welcome to the AIFC Court and International Arbitration Centre webinar series 2020, New Opportunities During and Post-COVID-19. Today we have webinar 8 in our series for 2020. The topic is Appeals to the AIFC Court from Regulatory Decisions. Today's speaker is Justice Sir Stephen Richards, who is one of our distinguished judges from the AIFC Court in Sultan Kazakhstan. We have 1 hour for today's webinar. So Stephen will give his presentation and we will then open the floor for questions. We ask you please to type any questions you may have in the Q's and A's option, which may be shown at the bottom or the top of your screens. And so Stephen will answer the questions at the end of his presentation. If I may, a very quick update from the AIFC Court and International Arbitration Centre to confirm once again that we continue during COVID-19 to provide all of our services 100% online using our e-justice e-filing system and video and telephone technology for hearings and case management work. We have to today's date administered a total between the Court and Arbitration Centre 82 cases comprising arbitrations, mediations and 2 judgments and orders from the court, 1 last year and 1 this year. I'd like to say very quickly that both of those court judgments and orders have now been successfully enforced within the territory of Kazakhstan to full satisfaction of those judgments. So without further ado, I'd like to hand over to Sir Stephen.
Thank you, Chris, and welcome everybody. The focus of the last few talks in this series of webinars has been on relations between different commercial parties, on force majeure and procedural issues such as freezing orders and other interim measures. My talk today has a different focus on relations between, on the one hand, AIFC participants, and on the other hand, the AIFC's regulator, the Astana Financial Services Authority, the AFSA, or the authority as I will call it. In particular, on the scope for appeals to the AIFC Court from decisions of the authority and the procedures governing such appeals. My intention is to provide a helpful overview, not to commit myself or my fellow judges to adopt a particular approach to specific cases as they come before the court. Anything I say about the way the relevant provisions are to be applied is obviously provisional and subject to hearing full argument in due course. The jurisdiction of the court to hear disputes between AIFC participants and AIFC bodies derives ultimately from Article 13, paragraph 4 of the constitutional statute on the AIFC, which defines in general terms the types of dispute over which the court has exclusive jurisdiction. More specifically, however, Article 26, paragraph 5 of the AIFC Court regulations confers jurisdiction on the Court of First Instance to hear appeals from decisions of AIFC bodies, which include, of course, the authority. It provides that the Court of First Instance has jurisdiction to hear and determine an appeal from the decision of an AIFC body, as provided for in the AIFC Constitutional Statute, AIFC regulations, AIFC court rules, or other AIFC rules where the appeal relates to A, a question of law, B, an allegation of a miscarriage of justice, C, an issue of procedural fairness, or D, a matter provided for in or under AIFC law. Section 11 of the AIFC Financial Services Framework Regulations fits within that jurisdiction in providing that a person aggrieved by a decision of the AFSA may appeal to the AIFC court against the decision. I will come in a moment to the grounds of appeal. First, let me say something about the powers of the authority and the kinds of decisions that might trigger the right of appeal. The authority has wide-ranging powers in relation to the regulation, control, and supervision of financial activities in the AIFC. One needs only look at the AIFC Financial Services Framework Regulations for the general picture. That picture includes a wide power to make rules, the power to grant or refuse applications for licenses and other forms of authorization, extensive powers of supervision, including the imposition or variation of license conditions, or the withdrawal or suspension of licenses, and the imposition of prohibitions and requirements. And there are extensive powers of enforcement, including the conduct of investigations into suspected contraventions, and the imposition of disciplinary sanctions where contraventions are established. The exercise of those powers may involve appealable decisions of various kinds. One particular area where one might expect appeals to arise is in relation to disciplinary sanctions. The authority has the power to impose a sanction if it considers that a person has committed a contravention. Section 119 of the Financial Services Framework Regulations covers the question of contraventions. They can be of many kinds, including a failure to comply with a prohibition or requirement imposed by the authority, the doing of anything that is prohibited under or that contravenes any legislation administered by the authority, failure to do something that the person is required to do under any legislation administered by the authority, committing an act of fraud or abuse of fiduciary duty owed to clients or customers or an authorized person, or acting in a deceptive, misleading, or dishonest manner. The available sanctions where the authority considers that a person has committed a contravention are set out in section 118 of the same framework regulations. They include a fine, censure, a direction requiring the person to effect restitution or compensation, a direction requiring the person to account for profits or unjust enrichment arising from the contravention, a direction requiring the person to cease and desist from activity constituting or connected to the contravention, a direction requiring the person to do an act or thing to remedy the contravention, and a direction prohibiting the person from holding office in or being an employee of an authorized person. I am not sure whether the situation created by COVID-19 makes it more or less likely that appealable decisions will arise. I note from a press release on the 20th of April of this year that the authority has introduced various financial market support measures to alleviate the negative impact on regulated firms. They include a relaxation of various reporting requirements by suspending deadlines or extending them until after the state of emergency in Kazakhstan has ended. In that respect, therefore, what might otherwise have been a serious risk of contraventions has been avoided. On the other hand, current economic pressures may well impact on the ability of AIFC participants to meet other regulatory requirements. The same press release of the 20th of April draws the attention of authorized persons to the importance of complying with requirements for systems and control, particularly for policies on risk management, cybersecurity, and business continuity, and on ensuring financial and operational resilience. It also states that the authority expects that prudentially regulated firms will actively manage their liquidity and should immediately report to the authority if there are reasons to believe the firm will be in difficulty, and all authorized persons should immediately inform the authority of any significant developments and matters that could impact their ability to meet regulatory requirements. It is possible that the authority will be asked to relax other requirements, and the question may arise whether a refusal to do so constitutes an appealable decision. It may be that contraventions leading to disciplinary sanctions are more likely to occur in present conditions than in normal economic conditions. Only time will tell. But in any event, the topic of appeals to the AIFC Court against regulatory decisions is at least as important at present as in normal times, and maybe more so. So let me turn to examine the right of appeal in more detail. I've explained that the right of appeal to the court against decisions of the authority is conferred by Section 11 of the Financial Services Framework Regulations. The grounds of appeal under the section are that A, the decision was ultra vires or there was some other error of law. B, the decision was unreasonable. C, the decision was made in bad faith. D, there was a lack of proportionality. E, there was a material error as to the procedure. Those grounds of appeal involve concepts familiar to practitioners in the field of English public law, that is, in judicial review, and various types of appeal provided for by statute. They are directed at the lawfulness of a decision, not at the substantive merits of the decision. They indicate that an appeal to the court is not a full appeal on the merits, but is limited to determining whether the decision was affected by legal or procedural error. Very importantly, therefore, the court does not become a primary decision maker, and it is not for the court to substitute its own judgment on the merits for that of the regulator. It is true that in determining questions of reasonableness and proportionality in particular, those matters I will come to, it may be necessary to look in some depth at the substance of a decision. But the limited nature of an appeal, the difference in function between the court and the regulator, have to be borne in mind throughout. The first ground of appeal is that the decision was ultra vires or there was some other error of law. That is to say, in broad terms, that the decision maker acted outside the powers conferred by the governing regulations or rules, or otherwise misinterpreted or misapplied the relevant law. A simple example of acting outside one's powers in the regulatory field is given by an English case in the 1980s involving the Monopolies and Mergers Commission, the body responsible at the time for determining whether a proposed corporate merger would be against the public interest. The chairman of the commission decided that a proposed merger, which had been referred to the commission for investigation, had been abandoned, and that the reference to the commission could therefore be laid aside. But the court held that under the relevant statute, the chairman acting alone had no power to make that decision. Under the statute, the decision was for the commission as a whole or for a group of its members appointed to conduct the reference. Whereas, because the suggested abandonment had taken place at an early stage of the process, no such group of members had yet been appointed. So the decision was unlawful. I should add, however, that the court nevertheless refused a remedy in the exercise of its discretion, holding that a properly appointed group of members would undoubtedly have reached the same conclusion on the particular facts. But that doesn't affect the legal principle that the chairman acting alone had no power to take the relevant decision. More generally, issues of legislative interpretation can arise in all sorts of different ways. In a case that reached the United Kingdom Supreme Court just over 3 years ago, the United Kingdom Financial Conduct Authority had published a notice imposing a penalty on an investment bank for various irregularities in the conduct of its business. The chief investment officer of the bank complained that the notice was in terms which identified him as the person responsible. The issue before the court was whether the notice did identify him within the meaning of the statute, because if it did, the statute required that he be served with a copy of the notice so as to provide him with various procedural protections in advance. The court held that a person was identified by a notice under the relevant statutory provision only if he was identified by name or by a synonym such as his office or job title, and that the particular notice did not identify the chief investment officer in this way, even though he complained that people in the market would have known who it was that the notice was referring to. On such fine questions of interpretation can important issues turn. Many of the authorities' decisions in Kazakhstan will be taken in the exercise of a wide discretionary power. But there are legal limits to any such power. For example, there has to be a genuine exercise of discretion, having regard to the circumstances of the particular case. Decisions can and should be guided by published policies, and policies are important for transparency and for promoting consistency. But policies must not be treated as inflexible rules so as to fetter the exercise of the discretion. There must be a willingness on the part of the regulator to consider arguments that the particular circumstances of an individual case justify a departure from the policy. Another limit on the exercise of a discretionary power is that the decision maker must take relevant considerations into account and must leave irrelevant considerations out of account in reaching a decision. The governing regulation may require certain matters to be taken into account or to be left out of account, and a failure to observe a requirement of that kind will be an error of law. Otherwise, it is left to the decision maker to determine what matters to take into account in the circumstances of the given case. Even there, however, there are legal limits. A matter may be so obviously relevant that no reasonable decision maker could fail to take it into account, or so obviously irrelevant that no reasonable decision maker could properly take it into account. That provides a link with the second ground of appeal, that of unreasonableness. The test of unreasonableness has been expressed in different ways over the years, but they all come down to asking, perhaps unhelpfully, whether the decision was one that a reasonable decision maker could take. The point is this: in an area of discretionary judgment, there may be scope for reasonable people to reach different decisions on the same set of facts, but there are limits to what can reasonably be decided. The court's role in such a case is to see whether the particular decision fell within reasonable limits. That itself is a limited role. It is not the function of the court, as I've already mentioned, to substitute its own judgment for that of the decision maker, or to substitute its own view of the substantive merits of the case for the view taken by the decision maker. It also follows that the court will not normally interfere with the decision maker's findings of fact, unless a finding is not supported by any evidence, or no reasonable body could have regarded the evidence as sufficient to justify the finding. Provided that the considerations taken into account by the decision maker are relevant considerations, the weight to be given to them and the balance to be struck between them are matters for the judgment of the decision maker, subject always to the question whether the ultimate decision reached was a reasonable one. And in determining that question, the court will give weight to the assessment made by the decision maker and will take into account the expertise of the decision maker, the nature of the issues involved, and, for example, whether the decision required the evaluation of complex material, including complex economic evidence. The more technical and complex the case, the more reluctant the court is likely to be in practice to interfere with the assessment made by the decision maker. The third ground of appeal is that the decision was taken in bad faith. I can deal very quickly with that. An example would be the refusal of a license or the imposition of a sanction because of some personal animosity on the part of the decision maker towards the person concerned. Or it might apply to a decision taken for some other dishonest motive. But bad faith is a serious allegation involving an attack on the integrity of the decision maker, and it is likely to be difficult to prove. I would expect it in practice to be the least used of the grounds of appeal. It could, however, have an important role to play where it is sought to disapply the immunity otherwise enjoyed under Section 11, paragraph 4 of the Financial Services Framework Regulations for things done or omitted to be done in the performance of the authority's functions or in the exercise of its powers. Turning to the fourth ground of appeal, lack of proportionality is a more refined concept than unreasonableness, though the two will often produce the same result. Proportionality focuses on a relatively structured analysis of the appropriateness of and necessity for the measure decided on. It is particularly important in relation to interferences with fundamental rights, where a four-stage test has been adopted under English law and is likely to be applied in the AIFC context. One, whether the objective is sufficiently important to justify the limitation of a fundamental right. Two, whether the measure is rationally connected to the objective. Three, whether a less intrusive measure could have been adopted. And four, whether having regard to those matters and to the severity of the consequences, a fair balance has been struck between the rights of the individual and the interests of the community. Proportionality does not displace unreasonableness as a ground of appeal, but it may be more useful than unreasonableness in particular contexts, such as the imposition of sanctions, where an analysis in terms of proportionality may provide a more nuanced approach towards determining whether a particular sanction is excessive relative to the contravention in question, and having regard to factors such as the hardship to the person concerned, and on the other hand, the need to uphold the effectiveness of the regulatory system and to protect the wider public interest. The final ground of appeal is that there was a material error as to the procedure. The starting point for any consideration of procedural error will be Section 10 and Schedule 1 of the Financial Services Framework Regulations, which lay down a detailed set of procedures to be followed by the authority, with limited exceptions, where a provision in the regulation or rules made under them requires or enables the authority to make a decision. The procedures laid down are plainly designed to ensure that the basic elements of procedural fairness are met in the decision-making process. In summary, the procedures are these. If the authority proposes to make a decision, it must first give the relevant person, that is, any person in relation to whom it proposes to exercise its power, a written notice specifying the proposed decision and the reasons for it, including any proposed findings of fact. The notice, which is called a preliminary notice, must also include a copy of the relevant materials considered in making the proposed decision, or refer to the materials if they're otherwise available to the relevant person, save for material that is the subject of legal professional privilege. And an opportunity must be given to the person to make representations to the authority in person and in writing concerning the proposed decision. If representations are received within the period specified in the preliminary notice, the authority must consider them in making the decision. If the authority then decides to make the proposed decision, either as proposed or with variations, it must give the person a decision notice. If it decides not to make the proposed decision, it must notify the person of that fact in writing as soon as practicable. A decision notice is a written notice specifying the decision, the reasons for it, including findings of fact, the date on which it is to take effect, the date by which any relevant action must be taken by the person, and the person's right to seek review of the decision by the court, that is, by an appeal. The decision must also include a copy of the relevant materials considered in making the decision, or again refer to those materials if they're otherwise available to the person concerned, save for material that is the subject of legal professional privilege. So one has that two-stage process of a preliminary notice followed by a decision notice or a decision not to take the proposed decision. There is one important exception to the requirements to give a preliminary notice and an opportunity to make representations in advance of a decision. If the authority concludes that any delay likely to arise as a result of complying with the procedures would be prejudicial to the interests of direct or indirect users of financial services, or otherwise prejudicial to the interests of the AIFC, then those pre-decision requirements do not apply. And the relevant obligation is limited to the obligation to provide the person with an opportunity to make representations only after the authority has made the decision. And if representations are then received within the period specified, the authority must consider them in deciding whether to confirm, withdraw, or vary the decision. Various questions can arise in practice as to whether the procedures laid down in the Financial Services Framework Regulations have been properly followed, and as to how they are to be applied in the circumstances of individual cases. For example, there is a simply stated requirement to give reasons, including any findings of fact. But issues may arise as to the adequacy of the reasons given. Reasons do not have to be lengthy, but they need to be intelligible and to address the main issues, and to say enough to enable those affected to understand why the decision is proposed to be taken or has been taken, and why any representations they have made have been rejected. As a further example, issues may arise as to whether sufficient time has been allowed for the making of representations, and so on. Each of the requirements has the potential for dispute in the circumstances of individual cases. Another question that might have to be considered is where the authority has dispensed with the pre-decision procedural requirements, the requirement to serve a preliminary notice, on the ground that the delay likely to arise as a result of complying with those pre-decision procedures would be prejudicial to the interests of direct or indirect users of financial services, or otherwise prejudicial to the interests of the AIFC. That judgment about the prejudicial effect of delay has to be a lawful judgment. The authority cannot short-circuit the decision-making process arbitrarily. It must have a reasonable basis for its conclusion that delay would cause prejudice, and it must act in good faith. In practice, however, it is likely to be difficult to challenge the authority's judgment on such an issue, given the weight to be given to the expert assessment of the regulator in an area such as this. A failure to follow the procedures may provide a ground of appeal, provided that it amounts to a material error. There could well be argument as to whether an error is material in the context of an individual case. The central question in that respect is likely to be whether there is any possibility that the decision might have been different if the error had not occurred. For example, if it emerges that the decision maker took account of a document on which the person was not given an opportunity to comment, it may be appropriate to consider whether that person would have had anything of importance to say about the document if he had been given the opportunity to comment on it. If he would not have had anything important to say, that might lead to the conclusion that the failure to give him an opportunity to comment on it was not a material failure. I have concentrated so far on the procedures laid down in the Financial Services Framework Regulations, but they are not exhaustive of the requirements of procedural fairness. For example, the decision maker must not have a direct financial interest in the case, or be biased or prejudiced in a way that precludes fair and genuine consideration given to the arguments advanced. Bias can be actual or apparent. Actual bias, like bad faith, is rare and difficult to prove, but the appearance of bias is a sufficient procedural error and is more likely to be relied on in practice. The accepted test for apparent bias in English common law, which one can expect to be applied also in the present context of appeals to the AIFC Court, is whether the fair-minded and informed observer, having considered the facts, would conclude that there was a real possibility of bias on the part of the decision maker. It is the court which has to decide how a fair-minded and informed observer would react. The appearance of bias can extend to any circumstances that establish the possibility of predetermination of the case by the decision maker, or of approaching the issues with a prematurely closed mind. There is, as it seems to me, an overlap here between ground A and ground E, in that discretionary power requires the exercise of a genuine discretion, so that any fetter on that discretion, any failure to approach the decision with an open mind, can be regarded as an error of law within ground A as much as a procedural error within ground E. But perhaps the categorization of the error does not matter. Finally, on the topic of material error as to procedure in decision-making, I think it worth emphasizing the importance generally attached to procedural fairness in the regulatory field. A fair procedure not only respects the rights of the defense or of persons liable to be adversely affected by a decision, but also helps to provide the decision maker with a fuller and better informed picture and promotes the quality of decision making. If one looks at United Kingdom cases involving regulatory authorities of various kinds over the last few decades, it is striking how high a proportion of them involve questions of procedural fairness rather than substantive law. I turn to the appeal procedures themselves. Schedule 2 to the Financial Services Framework Regulations sets out some key elements of the procedure to be adopted by the parties and the court on an appeal under Section 11. The main provisions in that schedule are these. An appeal may be instituted within 28 days of the date of the decision notice issued by the authority, and may be instituted by serving a claim form on the authority in accordance with the service provisions of the AIFC Court rules, stating the grounds and material facts on which the appellant relies. Importantly, an appeal does not operate as a stay of the decision being appealed. Nonetheless, the powers of the court on an appeal include the power to suspend or modify the operation of the decision on such terms as the court thinks just, pending the determination of the appeal. So an appeal does not automatically suspend the decision, but it is open to an appellant to apply to the court for interim measures in the form of suspension or modification of the decision pending the determination of the appeal itself. On the conclusion of an appeal, the court may confirm the decision in whole or in part, or it may set the decision aside, and if the court thinks it appropriate to do so, may remit the matter to the authority with such directions as the court thinks fit. A further point to note is that by Article 26, paragraph 5 of the AIFC Court regulations, which I've mentioned previously as regards jurisdiction, the jurisdiction of the court to hear appeals from decisions of AIFC bodies, including the AIFSA, is conferred on the Court of First Instance, whose decisions in such cases are stated to be final and are not to be subject to any further appeal. Furthermore, provision is made by Article 28, paragraph 2 of the court regulations for cases in the Court of First Instance to be heard by a single judge, except when a greater number is justified by the nature of the case and there is a sufficient number of judges available. So the general rule is that an appeal will be heard by only one judge whose decision on the appeal will be final. As is to be expected, the AIFC Court rules also contain important procedural provisions. Appeals generally are covered by Part 29 of the court rules. Rule 29.1 provides that the rules in Part 29 apply not only to an appeal from the Court of First Instance to the Court of Appeal, that's the typical case where such an appeal is available, but apply also to an appeal to the Court of First Instance, either from the small claims court or pursuant to Article 26, paragraph 5 of the AIFC Court regulations. That, of course, is the relevant provision, and it means that Part 29 applies in principle to an appeal against a decision of the AIFSA. But in order to give proper effect to Schedule 2 of the Financial Services Framework Regulations, it will, as it seems to me, be necessary to read Part 29 as applying with certain modifications to an appeal against a decision of the authority. Provision is made for that possibility in Part 29 itself, in that Rule 29.3 states in terms that Part 29 is subject to any enactment which sets out further provisions with regard to any particular category of appeal. And the Financial Services Framework Regulations are plainly such an enactment, setting out further provisions with regard to appeals from the AIFSA. The effect of this will have to be worked through in individual cases. There is ample flexibility in the rules to ensure that any procedural tensions between Part 29 and Schedule 2 of the Framework Regulations do not get in the way of doing justice. But let me give you some examples of what I'm talking about. Under Rule 29.10, the normal time limit for bringing an appeal to the court is 21 days from the date of the decision under appeal. But Schedule 2 of the Financial Services Framework Regulations provides, as I've said, that an appeal may be instituted within 28 days of the date of the decision notice issued by the authority. I would expect the time limit in the Framework Regulations to prevail. The normal procedure under Part 29 for instituting an appeal is by way of a document called an appellant's notice, in accordance with the requirements as to content and service set out in Rules 29.23 to 29.27. But Schedule 2 of the Financial Services Framework Regulations provides, as again I've mentioned already, that an appeal may be instituted by serving a claim form on the authority in accordance with the service provisions of the court rules. Under the rules, a claim form is the normal way of starting an ordinary claim rather than an appeal, and is subject to different detailed requirements as to content and service, as set out in Parts 4 and 5 of the rules. If a claim form is used in accordance with Schedule 2 to the Framework Regulations, it may be necessary for the court to give directions in order to bring the procedure more closely in line with that in Part 29. But I'm confident that the type of document used to institute an appeal is not going to affect the ultimate shape or outcome of the appeal. What is important is that whatever the type of document used to institute an appeal, that document should identify the decision being appealed, the grounds of appeal, why it is said that those grounds are made out, and the remedy sought. Another point is that rules 29.5 and 29.6 of the court rules provide that an appellant requires permission to appeal, except where the appeal is against a contempt order, not relevant here. The permission may be given where it is considered that the appeal would have a real prospect of success, or there is some other compelling reason why the appeal should be heard. Section 11 of the Financial Services Framework Regulations appears on the face of it, however, to confer a right of appeal without any requirement of permission to appeal. How the two provisions sit together will have to be decided at an early stage, but until the matter is resolved, the prudent course for anyone appealing from a decision of the authority would be to include an application for permission to appeal in the document instituting the appeal. Two final points I think it worth mentioning in relation to appeal procedures are these. First, Rule 29.7 of the court rules provided that the appeal court will allow an appeal where the decision below was 1, wrong, or 2, unjust because of a serious procedural or other irregularity in the proceedings. Those broad conditions accommodate without difficulty the various grounds of appeal set out in Section 11 of the Financial Services Framework Regulations, which I've already covered. And it is those specific grounds that will in practice form the focus of any appeal against a decision of the authority. Secondly, an appeal will normally be heard in public. That is the general rule for all court hearings, though departures from the rule are permitted in limited circumstances. See Article 32 of the AIFC Court Regulations and Rule 22.2 of the AIFC Court Rules. Schedule 2 of the Financial Services Framework Regulations makes express provision, however, that an appeal against a decision to publish a statement in respect of a person is to be held in private, unless the parties agree that all or part of the hearing should be held in public, or the court itself so orders. That specific provision can be expected to prevail in those cases to which it applies. Well, the subject of this webinar is appeals from decisions of the regulator. But I think it's right to point out that there are numerous other ways in which the court can in practice become involved in regulatory matters through applications to the court by the Astana Financial Services Authority or by other persons. For example, Section 28 relates to applications to recover money paid under an agreement made in breach of a regulation prohibition. Section 54 provides for an application to the court for directions about compliance with the business rules of an authorized market institution. Section 112 deals with applications for an order sanctioning a relevant transfer. Sections 124 to 126 concern applications for injunctions relating to the regulatory field. Sections 127 to 128 concerns applications to the court for restitution orders. Section 129 deals with applications for recovery of damages caused by an intentional, reckless, or negligent breach of duty, a requirement, a prohibition, or so forth, imposed by or under the regulations. None of those provisions is for consideration today, but they show the potential range of issues that can come before the court in the regulatory field. In conclusion, I hope I have said enough to show that the AIFC Court, and specifically the Court of First Instance, has a clearly laid down and potentially important appellate function in relation to regulatory decisions by the Astana Financial Services Authority. Thank you very much for attending the webinar. If there are any questions, I will attempt to deal with them now. Thank you.